Hey folks, Randy Newberg here with another episode of Leupold's Hunt Talk Radio. This one, I feel so stupid. I forgot to do the introduction for this, and we recorded the podcast about 4 days ago. So, anyhow, with me today is Dylan Soares. Dylan comes from a farm country background and is an engineer, I believe, by training, if I remember right. Then went to law school, clerked for the federal courts in the 9th District. Really is into hunting. Got into it in a really big way while he was in college. And works for a group called PERC. It's a group here in Bozeman. It's called the Property and Economic Research Center. I think that's what it stands for. But anyhow, I was at a continuing education seminar for attorneys last month, and he was one of the instructors. And he was giving the presentation about all the legal possibilities, legal ramifications, and maybe a little bit of a clue of what's in store under what's called the iron bar case, which we all call the corner crossing case. So, Dylan's input and the people he talks to, and just his keen interest in hunting, legal background, clerking in some of the federal courts, studying this case, studying all the law around it, is a very interesting perspective. And at that continuing education class, I really sat there because I'm just the CPA, right? I'm not admitted to the bar in any state. I just read tax law. But it was very applicable. There's a lot of things in that class. There was this. Another breakout session was about the legalities and litigation under the Endangered Species Act. And the third one was about the legality of the constitutionality of federal land and the attacks on federal land to try to dispose of it, everything else. But for this podcast, we're going to focus on the issue that Dylan presented on, and that is corner crossing in Wyoming. It's been affirmed as something you can do in the 10th District, 10th Circuit Court of Appeals, which includes the states where it really applies a lot would be Wyoming, obviously, Utah, Colorado, and I believe Arizona. Or no, not Arizona, but New Mexico. It has a couple other areas and states, but they don't have much public land. But I think those are the areas where it applies to the greatest geographic spread. And so we're going to let him do all the talking. And the other part I'm going to warn you is we shot this live in my studio, and we had a camera lined up over there on him, a camera lined up over here on me. And towards the end, I think his media card filled up, and the camera just stopped recording because the card was full. So, but anyhow, I know you're going to get a ton out of this. If you have a deer tag, elk tag, whatever, if you're going hunting in the 10th Circuit this year, and this is something you plan to do, I think Dylan's got some really good thoughts, ideas, and advice. And I suspect he's going to, like all attorneys, they always say, it depends on the fact pattern. It depends on the fact pattern. So he's probably going to remind us all, I know he does, about what the fact pattern was for the Wyoming hunters and how we should follow the same thing. So anyhow, appreciate y'all being here. Appreciate Dylan taking the time to come and do this. And I hope you'll enjoy this one. I know you'll enjoy this one. Stay tuned.
All right, folks, I prepped you that today is going to be a fun podcast. It's one I've been looking forward to for about 6 weeks, and I talked Dylan into doing this podcast with me. I think I caught him in a moment of weakness over at Bridger Brewery. We were eating pizza, not drinking, and he'd done a what would I call it? A continuing legal education.
Yeah, it's to force us lawyers to stay on top of topics and not lose our education that we paid dearly for.
Yeah.
To continue paying dearly for our education throughout our entire life.
Yeah. So as a CPA, I got to keep X number of continuing education hours. I got to do 40 a year. How many do you guys get?
Oh, goodness. Nowhere near that.
Really?
Depends on the state. Every state's different, and some states don't even have a requirement. But the state that the most for me is Colorado, and that requires 45 hours every 3 years.
Wow. No,
So
I got to have 40 a year. And even though I'm really out of the tax world now, I got one remaining client. Well, 2 counting myself, 3 counting my wife. I'm not as dialed in as I used to be, but I used to take about 100 hours a year just to stay on top of it. But anyhow, your employer, PERC, Property and Environmental Research Center, you are the Conservation Council. Did I get that right, Dylan?
Yes, Conservation Council, part of the semi-new Law and Policy Center, which started at PERC, I believe, in 2021.
Okay.
Yeah.
So you guys sponsored this day-long continuing education thing for attorneys, and I saw it and I called. I said, hey, I know I'm not an attorney, but my world lives here. Would you guys let me show up? And you guys let me show up there. So I sat there with all these attorneys, and I felt kind of stupid. Like, they're talking about certain cases. You guys were talking about the Kleppy case or this case. Like accountants, we talk about, depreciation methods. And I'm like looking back and forth. You guys probably thought he's lost. So I didn't ask as many questions as I didn't want to make a fool of myself, first of all. And I probably didn't understand enough to ask some of the questions. But I appreciate you guys letting me sit in, because we had your session that was updates on corner crossing.
Yep.
If we have time, I want to get into your approach to how you draw 2 or 3 once-in-a-lifetime tags every year. we just call Dylan, just call him Mr. Lucky. But anyhow, we'll save that to the end, because I think the reason the audience, one of the things they're really interested in is we had the case in Wyoming.
Yeah.
Which you went into great detail in that legal seminar.
Mm-hmm.
You went into how it got to the 10th Circuit, what the 10th Circuit said, and you analyzed all those cases. And then at that time, you said, well, the plaintiff has until June 16th to submit or request that it be heard by the U.S. Supreme Court.
Mm-hmm.
Last I heard, they asked for an extension.
July 16th. Yep. But that also gives us basically tells us that they are going to file to petition to the Supreme Court. So basically, before they filed for that extension, it was up in the air. We all assumed they were, but we didn't know for sure.
Right.
But once they filed for an extension and they made some arguments in that extension, kind of laying out what their major arguments are going to be for their petition, we are certain that or I shouldn't say certain, but relatively certain that they are going to file, and that will be July 16th.
Okay.
Yep.
So in your background, you clerked in the 9th Circuit.
Mm-hmm. Yeah, that's right.
This case was heard in the 10th Circuit, which used to be part of the 8th Circuit, if I understand
You're
correctly.
exactly right. And I don't know how deep we want to get into that split, but man, that is really interesting. How corner crossing has worked through originally the 8th Circuit, which then became the 10th Circuit.
Yeah.
So interesting history
And
for sure.
so I think one of the things we might end up getting into is trying to give the audience, because you're maybe the 3rd or 4th attorney in my 300 podcasts I've done. And that's nothing personal, Dylan. It's just, we talk about conservation and volunteerism and how to draw tags and how to shoot elk. And there's just not been many attorneys who we cross paths with in that. But
There's not too many attorneys that have probably drawn 3 lifetime tags in New Mexico either. So
Probably
there's not too many.
No, they're going to think you got a legal case against somebody or something. But
Blackmail. I promise there's no such thing.
yeah. So in all of this, most folks are familiar that I'm trying to remember the year 21 or 22, 400 from Missouri, go to south central Wyoming in an area called the Elk Mountain area, which is part of the historic checkerboard that was one of the railroad grants.
And it's just absolutely gorgeous area too.
Yeah.
To make clear, it is just outstandingly beautiful.
Yeah.
As well as being part of the checkerboard.
Yeah. And we'll get into the fact pattern, because fact patterns, you attorneys always say, are extremely important.
Yes.
They bring a ladder, they cross at a corner, and hopefully the audience understands what checkerboard means and what corner crossing means. It's like when checkers, you got to stay on black. So you go diagonally from black to black to black, or red to red to red. Here, you're trying to go from yellow, which is BLM, to yellow to yellow to yellow amongst all the white pieces, which are private.
Exactly.
So they end up in court, in Wyoming court, state court.
Yeah, exactly. For the criminal charge first.
Right.
Yep.
So they get cleared of the criminal charge.
Acquitted. Yep.
Yep.
Which, just to be very clear there, that doesn't mean that they couldn't bring criminal charges in the at that point. It wasn't clear that you couldn't bring criminal charges in the future. Just meant that the jury, based on the facts in that case, decided that they were not guilty of a criminal trespass.
Right.
Yep.
So in prior podcasts, I've had other attorneys on, Nick and Tom. They've been on twice. They were the ones who they started advising me on this stuff before I knew about the case.
Yeah.
Because I was trying to learn more.
Yeah.
And then the case comes out. I'm like, guys, you're not going to believe this. But the hypothetical we've been talking about is a case in Wyoming.
Yeah.
Anyhow, so when Tom and Nick have been on the podcast, they've talked about the distinction between criminal trespass and civil trespass.
Which a lot of the Western states have,
Right.
including Montana, I believe.
Yep. And since you are licensed in Colorado, which is a 10th Circuit state, and you're also licensed in California, which is a 9th Circuit state.
And licensed in the 9th Circuit technically as well.
Okay.
Yeah.
So for people who maybe didn't listen to those podcasts, I'm going to summarize in a layman's term, and you're going to correct me, I'm sure. Criminal trespass is, state law says, here's our criminal code. It's statutes. You violate this, the sheriff's going to come, and you're going to jail. Or you're going to get arrested. Or
pay a fine.
Whatever it might be. Then there's a completely different part of law that is our civil code, if you want to call it that. I know it's a code.
In most states, it is a code.
Okay.
Yeah, not to get into it. Louisiana follows the French system where it's a little bit different.
Okay. So you can be acquitted of a criminal action, but yet that doesn't prohibit a private party from bringing a civil claim against you. And the example I always give to people, and a lot of people, I age myself by saying this.
You're going to use the same one I think I use.
O.J. Simpson.
O.J. Simpson.
Yeah.
That's exactly the one I use.
Okay.
Yep.
O.J. Simpson,
It's the best one.
Johnny Cochran, and F. Lee Bailey get him off the hook for the criminal charges of murder, whatever it was.
Yep, he was acquitted.
Yeah. But then the family, the Goldstein family, sues him under civil actions.
Yep.
And they win.
Yep. Basically for the same thing. It was suing for unlawful death. So it's basically the same thing. The major difference in criminal and civil is criminal you need to prove beyond the preponderance of doubt, which means basically they don't tell you what percentage that is, but it's a lot. I shouldn't say that was wrong. You have to prove it beyond any reasonable doubt.
Right.
For civil, it's preponderance of the evidence, which is 51%.
Right.
And that's why there's always a major difference between the two.
Right. And so the other difference is a criminal case, you're usually going to have some body, a governmental body is likely who is pursuing the charge.
They have to. Yep.
So that's why you might end up in court and you're fighting with a district attorney or
Prosecutor.
a prosecutor or whoever. In a civil case, the sheriff and the county attorney and the prosecutor aren't who you're fighting against. Your attorneys are fighting against the attorneys of the plaintiff who brought the claim and made you the defendant.
Yep.
So, just so people understand that, because that's a unique thing that happened in this case. So along comes Iron Bar Holdings. Is that?
I think that's right. I have iron. We always call it Iron Bar. Yep. But yeah, I
And
think
a lot
it is
of
Iron Bar
people
Holdings.
want to use the name. It's the landowner or the guy who owns Iron Bar Holding as a person from North Carolina.
I was going to say, I think he's a pharmaceutical executive from North Carolina,
Yeah.
but I don't want to be, I don't know exactly for sure, but something like that.
Doesn't matter.
Nope, not at all.
The group making the claim is his LLC.
Yep.
That says, you have violated my rights and you have created damages of this amount.
Yep.
We're going to court.
Yeah.
So now the 4 hunters from Wyoming who thought, wow, I got off the hook. I didn't get a citation. I'm not going to get a fine. Get a letter, a subpoena saying, hope you got a lot of money because we're here to get it from you.
Yeah.
And we're going to sue you for this.
I think they sued for like $7 million or something like that.
Yeah.
So pretty much worse than the criminal charge.
Yeah.
I guarantee the fine wasn't going to be $7 million if they were found guilty there.
Yeah.
So
that goes there to the. I'm trying to remember. That claim was filed where?
the state court in Wyoming.
Right.
I can't exactly say which state court, but let's just say state court in Wyoming. And basically what happened then is that the Wyoming hunter, and again, these hunters are not from Wyoming, but the hunters in Wyoming then what's called removed the case to federal court.
Right.
And the way that you can do that is when this is getting a little bit in the weeds, but it's called diversity. So if you have if on one side of the lawsuit is a citizen from one state and the other side of the lawsuit is citizen or citizens from another state, and the amount in controversy, aka what they're suing over, is over $75,000, you then have the right to remove it to federal court. And that's what happened here, because the hunters were also from the South, but again, they were in a different state than the LLC. And again, not to get in details, but the owner of the LLC.
Right.
Yep.
So their attorneys got it removed
Federal
to
district
federal
court.
court.
Mm-hmm.
So in federal court, the four hunters prevail again.
Yes, at summary judgment stage.
Yeah. Well, the LLC and its owner says, I still don't like that outcome. 10th Circuit, here we come.
Yep.
So tell me in the audience how a case, because you clerk doing this in the 9th Circuit.
Yeah.
How does a case, do they have the right to say, oh, we're not going to hear that? Or do they have to hear it?
Yeah. So basically the best way to understand the federal court system in the United States is a system of 3 separate courts going up and going up. So at the bottom level, you have the federal district courts, which are basically easiest explained as trial courts. Every state at least has one district, and some states have more than one district. And then at that point, if you don't like how the outcome in that case came, you can then appeal to the appeals courts. And I'm going to get this wrong, but I think there's 13 appeals courts in the United States. There are 11 that cover various states, and then you have the D.C. Circuit, and then the federal circuit, which covers very specific claims. Okay. So in this case, Wyoming is in the 10th Circuit, so they appeal to the 10th Circuit, and they have the right to do so. And then your final option is to appeal to the Supreme Court, which is when we get into most of the time, the Supreme Court has has discretion to choose its caseload. And then, again, not to get in the weeds, there are some discussions on what is discretionary and what's not discretionary, but for this purposes, this case would be part of their discretionary caseload. So Iron Bar Holdings had the right to appeal to the 10th Circuit, and they exercised that right.
So they go to the 10th Circuit. We sit on our kind of keyboards waiting to see what the outcome is.
Pins and needles for over a year, I think.
Yeah. And that case came out this winter.
It came out in March, if I'm not mistaken.
Yeah. So the court ruled, issued a lengthy opinion, gave its rationale for why they decided, made a few statements of facts and other things, and the hunters prevailed again.
Yeah, they upheld and affirmed the district court. However, as we'll probably get into, the reasoning was, I wouldn't say drastically different, but significantly more broad than the district court's ruling, which is actually, I think, the most interesting part about this case.
Yeah. So that all happens. The plaintiff again has until June 16th.
At that point, they had until June 16th. Yes,
to
sir.
tell or to ask.
To file, it's called file a petition of cert, and I'm going to mess up my Latin because I am definitely not Latin. Petition of certiorari. So that basically just means you're telling the Supreme Court, hey, I want to appeal this case, and you're giving the Supreme Court your reasons of why you want to appeal the appeals court decision.
Okay.
Yep.
So they have until June 16th. They file a 30-day request or a request for a 30-day extension
in May. Yep. And just so everyone's clear, these extensions are routinely granted. So the grant of this extension bears absolutely no weight in whether the Supreme Court will take the case or not.
Right.
These extensions are, I wouldn't say, let's just say almost always granted.
Yeah. So if the extension's granted, everybody has to buckle down and get their work done. And then we're going to be in a wait-and-see mode again because there's no mandatory requirement that the U.S. Supreme Court takes this case.
We are in a wait-and-see mode. However, since we have so much data on the Supreme Court, we have a general idea of how things work. Mm-hmm. So basically what happens is Iron Bar is going to file their petition for cert on July 16th because that's when it got extended. The respondents, the hunters, are able to reply to that within 30 days. However, they can also ask for an extension.
Okay.
But again, to be very clear here, when they ask for an extension, it is only 30 days. You can't. It's kind of like, the best way I describe it is like when you're working as a lawyer in front of court, it's kind of going to school. You have these deadlines and you have to get your work done. But unlike school, you can always ask for an extension, but you generally don't get more than one extension unless you have some really extreme circumstances. So the respondents will be able to respond by August 15th, I believe is what I had down. And then at that point, that's where stuff starts to get interesting. Okay. So we have Wyoming that might want to weigh in, and that might extend how long it goes. We also might have what's called a reply brief. So this is when Iron Bar would reply to the hunters trying to argue that that Supreme Court shouldn't take the case. Again, unlikely. Wyoming is likely. At that point, the whole case would be briefed around end of August, roughly. And that's if there's no extensions. If there's extensions, we're looking at September. Okay. What that means is we are pushing when the court may take the case all the way into 2026.
Right.
But here's the other thing, the other really interesting wrinkle. This is what we have, what we call, again, like I was talking earlier, a preemption case. So we have a federal law that is preempting or overruling a state law. And in this case, the federal government won. So what is probably going to happen is this is going to be our key of whether the Supreme Court's going to take the case or not.
Okay.
In August or September, the court is either, this is all most likely, they're going to what's called schedule the case for conference. So the case is distributed to the justices in a conference. After that conference, the justices will likely deny the case. They will ask for the opinions of the Solicitor General of the United States, or they will what's called relist it for a later conference. So if they deny the case, the 10th Circuit ruling stands.
Okay.
And the Supreme Court doesn't give any ruling. If they ask for the opinions of the Solicitor General, then what happens is the Solicitor General will file a brief either supporting the 10th Circuit ruling or saying, hey, the 10th Circuit got it wrong. This federal law does not preempt corner crossing, state trespass, that sort of thing. And he will generally file that brief in January. And then in January. And then if they relist it, that is a good sign for Iron Bar that they're going to take the case. But again, we don't expect them to relist it without hearing from the SG. So now we're in January, right? Again, assuming that it wasn't denied. The SG files his brief, and at that point, the Supreme Court will either deny the brief or grant the brief, deny the petition for certiorari or grant the petition for certiorari, and we'll find out about that January, February. And the interesting part about that is that's really at the end of their term. So they could put it into, and now we're talking about 2026, but they also could push it to the next term where it's the end of 2026, beginning of 2027.
Right.
So the way I've been kind of telling people is we're either going to probably find out that they're going to deny the case at the end of, deny the petition for certiorari at the end of this year, or we're going to find out that they grant the petition of certiorari early next year.
Okay.
That's kind of the timeline. But like most things in the legal world, it is way more convoluted than it absolutely needs to be. If we just followed school rules and we got everyone to file their briefs on time, we would be all good and dandy. But lawyers as a breed are chronic procrastinators, and I can guarantee I'm one.
Okay. So what is relevant and important at this point, and what then becomes speculation at this point? Speculation is what the Supreme Court would do, what other circuits would do.
Yep.
But we do know what happened and where we're at with everything related to this case right now. So in my disclaimer, I told Dylan that if he came on this podcast, there would be a disclaimer that nothing he says is legal advice.
Yep, nothing is legal advice whatsoever, and especially since I am not admitted to the state of Montana or any other state, basically, other than Colorado and California, and I am not anyone's lawyer. I'm trying to just give some friendly advice
to me.
Exactly, give friendly advice.
For the purpose of having a discussion.
Exactly.
Right. So we're not going to read it really fast, like when you hear these legal disclaimers on Sirius XM.
Yeah.
I always think that maybe something's wrong with my radio.
Yeah.
I'm going to say it real slow. To all of you listening or watching, nothing you hear on this podcast can be, should be, or will be construed as legal advice that you should rely upon.
Or that I'm anyone's lawyer.
There you go. All right. With that all said, we find that if you have an elk tag in Colorado, 10th Circuit, Utah's in the 10th Circuit, isn't it?
Yeah.
Wyoming, parts of Kansas, parts of Oklahoma,
so
New Mexico.
It's always the full state. So yeah, you got all. Again, I'm not an expert of the 10th Circuit once we get out of the West, but I think you are right. It's Kansas, Oklahoma, New Mexico, Utah, Colorado, and Wyoming. Yep.
So, am I fair in saying, for the time being, until we hear otherwise, the decision of the 10th Circuit in the Iron Bar case is what those states are supposed to look to for similar, same fact pattern, same activity, same action.
And that's the key part. I mean, we can all kind of speculate how far this case goes, but what we can say for relative certainty is that if you did exactly what these hunters did, which is not touch any private ground, know exactly where the corner is, and cross at a corner on a checkerboard piece of land that is not accessible in any other way in the 10th Circuit, which are the states we just listed, the 10th Circuit case in Iron Bar does say that any sort of state trespassing law will be preempted by the Unlawful Enclosures Act.
There we go.
That's
so you highlighted so many things, Dylan. Where do we want to start with all these things? The Unlawful Enclosures Act, or do we want to start with the fact pattern?
I'm going to go based on what I was told to do for the presentation, and I think we should start with the high level points of Iron Bar.
Okay.
And as you saw in the CLE, that the continuing legal education class that we taught, there is so many different levels to this case and to this issue.
Right. So for those of you wondering, this is the course outline I got, and Dylan did a great job walking through this. And I wrote notes in the corners. I appreciate you guys allowing me to write notes at the bottom.
The only thing I do want to add, and this is just real quick, I just want to say that we partnered with National Wild Turkey Federation for this, and I do want to give them a little bit of credit because they were great partners on this CLE. But it was, like you said, it was a fantastic CLE, and the issues we covered, even though they were legal-based, were they relevant to hunting and public access, right?
Yeah, very relevant.
Very relevant.
And so it wasn't just those of us who were in Bozeman at your
No,
office.
yeah.
There was remote. People could join.
Goodness, we
remotely.
had somebody from New Jersey, I believe,
Yeah.
which is just incredible. I mean, I really hope the person in New Jersey learned a whole lot about Endangered Species Act and corner crossing because
and federal land disposal.
exactly. I mean, it must have been. I'm glad we had such a wide range of people to join because I mean, you were there in person, man. We had such a great discussion as well. It was fantastic.
Yeah. So all these highlight things.
Yeah.
I'm going to let you kind of go through it because I was taking notes, and I'm the conservative accountant. I always am in everything I do take into consideration property rights and private property rights.
Absolutely.
It's foundational to our country. It's foundational to our systems of law, of our economy. And I always work on the side of caution towards that.
Yep.
So,
absolutely. Especially in this sort of sense where not only are you trying to respect your fellow Americans, your fellow private property owners, but a lot of these private property owners are conservationists themselves.
Right.
But on top of all that, hunting, and I mean, as much as I wish we had a United States constitutional mandate, hunting is a privilege.
Right.
And we got to treat our private property owner partners when we're using this privilege. So it's something that you really should take into account whenever you're doing any sort of thing like this, which is, I don't want to say infringing on private property rights, but again, according to the 10th Circuit and Wyoming law, you are infringing on private property rights. It is just that it is not against the statute.
Right. So, walk us through these important facts, and I'll try not to interrupt, but I know I'm going to have to interject and ask more questions, Dylan.
You absolutely should. I'm going to do my best to give the 1% of attorneys a good name and not be part of the other 99%. And please interject because I dang sure can get in the weeds pretty easily. So what's really important to remember here is the fact pattern. Right. The fact pattern here is you had hunters, and to be very clear, they corner crossed twice, right? They corner crossed in 2020 and they corner crossed in 2021. However, the 2020 fact pattern wasn't in play. And that's when they touched the fence, which, as many people might understand, that might seem very minimal, but touching the fence actually creates a totally different fact pattern, right? Because you're touching private property. Yeah. So the fact pattern here, like you really, really well said, is they were on BLM land. They knew where the corner was because it was marked with a survey marker and 2 fence posts with a sign saying no trespassing. They put a step ladder over the fence, and without touching the fence or private land, because they knew exactly where it was, they crossed over to BLM. Right. And they did that several times. Yeah. And in doing so, never touched private land. They knew exactly where the public land was. And again, this public land is totally inaccessible in any other way. It is completely locked off. Do you think your audience is familiar enough with with checkerboard?
Yeah.
Okay, perfect. Because that is another thing that is really important here is that this is specifically checkerboard. And the reason,
and I want people. Let me make sure that I want to back up there. Mm-hmm. A lot of people think that anytime 2 corners touch, that's checkerboard.
No. Yeah.
This was one of the railroad land grants that created checkerboard. Yep. If you look at I-80 going across southern Wyoming, and then where I-80 continues across Utah, to a lesser degree, they through trades or otherwise, they've lessened some of that in Utah. Yeah. You get back in Nevada, and where I-80 goes, it's all checkerboard again.
Yeah, absolutely.
So, the court, in the opinion, if I understood it correctly, made quite a distinction about this being the checkerboard.
So this is where we have to be real careful, because the district court was super narrow. It laid out all the facts in this case so exactly, saying that like this is the fact pattern where the Unlawful Enclosures Act preempts or overrules state law. Right. And to be completely honest, the 10th Circuit wasn't as narrow or as careful. It brings up the checkerboard. Mm-hmm. It talks about all the facts that we're talking about, but it didn't rely on it as heavily as a district court. Right. But again, for your listeners, And if you really want to follow what is totally held under this case, it is best to do what the district court said, which is follow it almost to a T.
Right.
Yep.
Okay. So these guys went through great pains. These 4 Missouri hunters, what they went through and the steps they took to make sure they did not touch private land is significant.
Absolutely.
It wasn't, oh, this is close enough, or, oh, we'll climb over. He's got a gate here. Let's say it's easier to climb over the gate than to climb over the 4 strands.
Yep.
No, they carried a ladder. Mm-hmm. So
yeah, exactly. They may, again, like I said, in the 2020 situation, which was a little bit different, but in 2021, they took great pains not to touch any sort of private property or private land. And that is, again, since that is mentioned in the case, that is central to the holding, whether or not it is, again, district court took great pains to lay it out, where the 10th Circuit did not take as many steps to do so. Yeah. So they did that. And again, I think you laid out pretty well what happened to the hunters after that, getting charged criminally and then getting sued civilly. And then going into what the 10th Circuit said. Again, I'm going to keep saying this just so everyone knows. The 10th Circuit held that in Wyoming, corner crossing and crossing private airspace, or the airspace over private property, is trespass under civil law.
Civil trespass.
Civil trespass, exactly. And what they said, again, is that civil trespass is preempted by what's called the Unlawful Enclosures Act. And to give some, now I think we do need to get into the history of this thing, right? The Unlawful Enclosures Act is an act that was passed in the 1800s, and it basically was passed because of this checkerboard and the railroad grants that we were talking about. You had people that were successors that owned the railroad grants that were blocking off public land, either fencing off water sources, because we're talking about the Western United States where, man, there's just not a lot of rain, right? Really arid, blocking off the water sources, blocking off public access to the grazing, and blocking off, homesteaders and mineral development. So Congress came in and said, you can't block this stuff. And basically said, we're not going to allow you to fence off public parcels. Again, we can, as Randy saw, us lawyers can talk about these cases from the late 1800s and early 1900s, and range wars and sheep herders and cattle drivers. But I'm going to save your audience the pain of getting into the legal details. But basically, the most important thing to know is these early cases all dealt with what's called range wars. So you had different livestock producers and grazers fighting each other, sometimes physically, sometimes legally, a lot of times both. Preventing access to public lands. And basically in all of those cases, there's cases in the Supreme Court and there's cases from the circuit courts basically said you cannot fence off or prevent access to public lands. And then we get to Leo sheep, which is a really interesting case, I believe, from the 1970s, that had to do, again, with Wyoming. As you guys are going to probably notice if you dig into this, Wyoming is the epicenter of corner crossing, checkerboard, and all this sort of
Leo sheep case is, if I remember right, is in the same county as what the Iron Bar
I think
case
it is, but it's north of I-80.
It's north of I-80 instead of south.
Exactly. But that is,
I think they're all in Carbon County.
Yeah. Only know Carbon County because the unit that the Leo sheep case takes place in, right?
Yeah.
So Leo sheep basically said, and again, we're going to paraphrase here, what the government wanted to do is you have this publicly owned reservoir and publicly owned land on the north side of the reservoir. So you can access the reservoir from the north side, and you had public land. And the federal government said, well, because it's Unlawful Enclosure Act, what's stopping us from building a road on the corners to the reservoir and to this public land? We're going to be crossing private land, but the Unlawful Enclosure Act lets us do this. And the Supreme Court basically said two things. One, because the federal government can take land by what's called eminent domain. Right. And basically eminent domain is when the government goes through a process to take somebody's land but pay them fair value for their land. The government can't do what's called a easement by necessity, or which is again, we're trying to stay away from all the legal details here, but an easement by necessity is exactly what it sounds like. It's when you need an easement to reach your land by necessity. Right. But because the government can take land by eminent domain, there's no necessity to do that.
Right.
And on top of that, again, this reservoir and land was accessible from the north. So the Supreme Court said, you can't do this. This is not an Unlawful Enclosures Act case because you're not trying to get public access. You're building a road.
Yeah.
And you're building a road across private land, and that's a taking under the federal Constitution. So, and then the Supreme Court in that case also distinguished all those older cases we were talking about the range wars, and basically said three things that distinguished them. One, a lot of those cases dealt with open range, which I'm not an expert in open range, but basically open range is a old common law that had to deal with grazing. Then second, you were dealing with you're dealing with the fact patterns of the day, which is you're having grazers trying to access public land for grazing. You're not building a road. You're not dealing with any of that sort of thing. And third, you weren't dealing with an area that had public access. The reservoir
was no other way.
Exactly. The reservoir was accessible from the north. And all this in that case is what we call dicta. And the best way to describe dicta is stuff that is not central to the holding in the case. So basically no one knows whether it's actually the holding or whether it's just the Supreme Court getting on their soapbox, which is really interesting. And yeah.
You mean they actually do that?
Oh,
get on their soapbox.
Oh, man. It's kind of funny. If you're not a lawyer, you'll never kind of see judges getting on their soapbox. But especially in the recent past, as long as I've been a lawyer, man, there's a lot of judges getting on their soapbox, and it's pretty entertaining if you know what to look for. It's entertaining for legal nerds, put it that way. So that was Leo Sheep. And then we have a 10th Circuit case that came out in the 1980s, I believe, either late 1970s or the 1980s, called Bergen versus Lawrence. And this dealt, interestingly enough, with a landowner who was found to be blocking access to Pronghorn to the Red Desert. Yep. And again, maybe Carbon County, but it also might be the county just west of it.
It's either Carbon or Sweetwater.
Exactly. Yeah. Yep. So basically in that case, the 10th Circuit said, okay, Leo Sheep makes total sense, but it only applies to building roads and taking land. Here, what we have, a landowner fenced off access to wildlife to public land.
Right.
Totally different case, according to the 10th Circuit. And in that case, the 10th Circuit said Leo Sheep doesn't apply here because we don't have a taking. We don't have the government trying to build a road on private land. Instead, we have wildlife trying to access public land. And this is what gets really interesting in courts and cases. In that case, the district court made a finding of fact. So when we talked about facts and law, in this case, the district court actually found, as a matter of fact, that the antelope pronghorn could not reasonably access to public land, and the appellate court said because of that factual finding that the pronghorn couldn't access the public land, that fence had to be either replaced with BLM wildlife friendly fencing or taken down completely. Yeah. And basically what it did, what us lawyers call distinguished Leo Sheep, which says that Leo Sheep is still good law. It's binding on us, but it doesn't apply in this case. Okay. And that's what's actually really interesting about Iron Bar. Iron Bar said the same thing. Said that
Leo Sheep does not apply. This isn't the BLM or the federal government trying to build a road across Iron Bar.
Yep. Exactly. But to also be very clear, we all have to understand that Iron Bar is going to argue the exact opposite. Right. And that's what they're going to argue in front of the Supreme Court, which is like, look at this Western Circuit Court just ignoring your case law. And you could see that from their original filing. That is going to be their main argument, is that you have this 10th Circuit basically saying that taking to the Supreme Court, you have this case, Leo Sheep. They've distinguished it to the point where it really doesn't even apply to any of these cases. Please rehear this case. So, yeah, you're exactly right there.
Okay. So, that case, Bergen got decided in favor of the pronghorn, I'm going to say.
Exactly. In favor of the federal government suing for the pronghorn, which is pretty funny.
Yeah. And if I remember right, that landowner I think he sold some of that property and it's now a wildlife management area. If I remember right, it's a Red Rim Daily wildlife management area in Wyoming, or part of his property.
Absolutely makes sense.
Where there's no fences and the pronghorn can just go from private to public, because they do migrate.
Oh,
And-
yeah. I mean,
and
it's
so-
amazing. People don't realize how. I mean, that's one of the largest. Isn't that one of the longest migrations in North America or something like
Yeah.
that? It's a crazy migration.
Yeah. So that case then became something that, how did that impact Iron Bar then?
Yeah, so that is the primary case that the Iron Bar court relied on.
Okay.
Because the way that these appellate courts work is any prior case in the same circuit binds future circuits, binds future courts in that circuit, future cases. So because that case came before Iron Bar, it binded the Iron Bar court. And again, basically, there's
exceptions to every rule.
The exceptions is what's called en banc, is when the full court hears a case and then they can overrule prior circuit precedent. Yep, which did not happen here.
Okay. So the important part there is the fact pattern that got us here. These guys did an amazing job. The fact that this wasn't the federal government coming to a landowner and saying, "Oh, we're going to build a road across your corner."
Yep.
This was some private parties doing everything they possibly could to not touch the private ground and did not do so.
Yep.
And overcame the obstacles intended to keep the public off the public land.
Exactly. And that is what they said at Iron Bar, right? Is that because there was an effective barrier to the public land. Because again, to remind everyone in this case, there weren't like all these fences around the public land. It wasn't like there was this physical barrier, right? There was this legal barrier. And what the 10th Circuit said in Iron Bar is that a legal barrier to the public land is still a barrier that cannot be used under the Unlawful Enclosures Act.
Yeah. So, Unlawful Enclosures Act is deemed to preempt the finding that under Wyoming law, this was civil trespass.
Yes, exactly. And again, that's the really interesting part to like really hammer home is it was held as civil trespass by the 10th Circuit. So the Wyoming courts or the legislature can always come in and change that. They're just unlikely to do so. So that's the kind of interesting wrinkle here is Wyoming's never actually had the final say on what is civil trespass regarding crossing the airspace or corner crossing in Wyoming.
Right.
The 10th Circuit made that decision.
Okay. So for a lot of people who are trying to figure out this airspace thing and they're trying to extrapolate it and apply it to different fact patterns, because that's the thing that interests me is how many people have got a hold of me and said, "Oh man, I'm going corner crossing."
Yeah.
I'm like, okay, how are your facts? Are they going to be, are you going, and so maybe we get into some of these hypotheticals and I'm not asking you for an opinion. I'm asking for your thoughts about, will a court look at it differently because of these different facts? So,
I mean, like what we like to say in the legal field is different facts and different cases result in different law and different holdings, right?
Right.
So like what you just said is spot on. You know, everyone that ever does this is going to have different facts. The question is, how close are your facts?
Right.
And there is one really important thing that I want to mention about the Unlawful Enclosures Act.
Sure.
The Unlawful Enclosures Act only operates as a defense for the public.
Okay.
The federal government can use the Unlawful Enclosures Act like it did in Bergen versus Lawrence to force a landowner to allow access. But as a private party, we're only allowed to use it once we're either charged criminally or sued.
Yeah.
So that's something that's really important to remember is this is kind of all at your own risk. Even if the 10th Circuit said this, the only time you're going to be able to use this is when you are actually already in court.
Right.
So that's just something, again, I don't want to be this, like you said, CPA being real conservative, a lawyer and an engineer, also very conservative. Don't want to be throwing water on all this, but it is really important to note that like that's how this is going to go if you're going to use this, is you're going to be sued.
Yeah.
And in the 10th Circuit, you have a lot of good law on your side in this very specific circumstance, but you're still going to be in court.
Right.
Yep.
So knowing that you might be in court, some people would be like, hell with it. I'm pack a lunch. I'll see you in court.
I hope they have a good friend who's a lawyer then, because thankfully I'm not in private practice, but I do know those charges aren't cheap unless you're getting a lot of donations. So,
right.
I wish them all the best, frankly.
And this legal defense allowed the 400s to get excellent legal counsel.
Oh, absolutely.
Through a GoFundMe action.
Yeah, they had a lot of support, which is, and again, we all, there's nothing wrong with that. They deserved it.
Yeah. So some of the things that I know people are contemplating are outside of the 10th Circuit.
Absolutely.
And you clerked in the 9th, which we're sitting in the 9th.
We are.
In Montana.
And I believe, as a whole, you have it in front of you, actually. I think the 9th Circuit actually has more checkerboard than the 10th Circuit as a whole.
Yeah.
It's like,
there's a lot.
There's millions of it. Exactly. So you're exactly right that the 9th Circuit looks like you could be kind of salivating at the mouth. Oh, I can start doing this in Arizona and Nevada.
Right.
But really,
the landlocked acres in the 9th Circuit are significantly more than they are in the 10th Circuit.
Exactly.
Wyoming is the largest of any state.
Yeah.
But its surrounding states of Colorado, Utah, they don't have a lot.
No.
They have some, but not a lot. Montana has 870,000.
Yeah.
Oregon, 470,000. Nevada, almost 2 million.
Yeah.
Arizona, 1.3 million. So total acreage, yes.
Absolutely. And that kind of also makes sense if you think about the 9th Circuit. The 9th Circuit is the largest circuit in the United States, both by landmass and population.
Right.
But
of all states, Wyoming does have the most
absolutely
landlocked, corner locked, I would call it.
Yeah,
acres.
because again, the map you're looking at is, I don't think that's actual it's not checkerboard, right? It's just
Correct. Any place 2 corners hit.
Yeah.
Right.
Which that's what we're talking about. Like,
right.
If you really want to push your luck, it's a different ball game when you start trying to corner cross land that isn't checkerboard and not railroad grant checkerboard.
So a lot of people say, well, how did something end up being 2 corners touching that's not checkerboard?
Yeah.
Well, it easily could have been due to another land exchange.
Yep.
It could have been due to the federal government purchasing land subsequent to the railroad land grants. A common one in Montana is homesteaders.
Exactly.
Came and they ended up with a 320 or a 640, which, a square mile is 640 acres. They couldn't make a go of it, but their neighbor could.
Exactly. Yeah.
Or you have 3 neighbors who couldn't and 3 neighbors who could. So now you have the corners touching, because when the 3 who couldn't, their land got foreclosed on and brought back to the federal government. And if you look under the old surface maps, it called it Bankhead-Jones Act lands. Well, they're owned by the federal government, but they aren't per se checkerboard.
No. And the other thing that you have is you have these homesteaders that then bought out their neighbors at some point too. So you get these large land holdings that also have, are touching corners. It's not just railroads. It's all this sort of like old statutes and old homesteading and, exploring the West that happened in the 1800s and early 1900s that have got us here where we're today.
Yeah. So would a court, is that a big enough deviation from the fact pattern that the court you've clerked in would say, yeah, that's pretty material difference in the fact pattern?
Well,
did this court address it at all?
Yeah, so let's get into that. So I see that as 2 separate questions, right? So the first question that I see is, how would the 10th Circuit approach it? Because the 10th Circuit has iron bar. It's not legal advice, blah, 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 all that sort of thing.
Yeah, disclaimer, fully in effect.
Fully disclaimer. This is me giving just, corner side opinions of guessing. Basically, I think if you had 2 corners and it was not a checkerboard, I think under iron bar, you can corner cross as long as know where the corner is, don't touch private land.
Right.
All
no
that
other means of access, blah, blah, blah.
And the reason I say that is because unlike the district court in the Wyoming district court, which took great pains to talk about the railroads and the checkerboard, Iron Bar, the 10th Circuit did not do that, which is really unique.
Okay.
They really basically said if public land is inaccessible caused by surrounding private landowners, you can corner cross to get to that public land.
Right.
But again, that's why we keep hammering the point of like not touching the private land, because what they also said was we haven't held that you can't get damages for damage you caused to private land. We've not held that you can't. We have not held that you can trespass, stuff like that.
Right.
But now let's get into the Ninth Circuit. This is where it gets really interesting.
Okay.
Fellow circuits have no obligation to follow sister neighboring circuit precedent.
Ninth can say, you know what, 10th Circuit, we think you guys are smoking something over
Yeah,
there.
exactly. And like that's the really interesting thing here as a lawyer, as a nerd, frankly, is that the Ninth Circuit has this precedent that I think you remember us talking about from 1913.
Right.
And again, all these cases are old, so we're not going to get into the gist of, we're not going to get into the whole of it, but the gist of the Ninth Circuit case, that it makes it really quite a bit different than the 10th Circuit, is the Ninth Circuit held that under the Unlawful Enclosures Act, we consider the landowner's intent, which is really fascinating because, again, not to get into legal issues, that was probably wrong, to be complete. And I don't mind saying that because all the judges that did it were not judges that I worked for or worked with.
Yeah.
They're all long gone. But it was almost certainly wrong to say that. But the 10th Circuit said, we don't consider intent. It is whether public access is prevented by private land. So in the Ninth Circuit, not only does the land have to be not only does the public land have to be completely enclosed or legally prevented to get access, but you then also consider, is the private landowner's intent to prevent access, or is he trying to prevent, I don't know, trespassing, or maybe there's wild cat, depending on where you're at, right? Maybe you're trying to prevent wild animal, like or livestock or something, right, to getting into your land. But here's the thing: the Ninth Circuit has not had a corner crossing case or any Unlawful Enclosure Act case since I think it was 1913.
Wow.
So we're basically trying to guess based on a completely different Ninth Circuit, and we're trying to guess what is the Ninth Circuit going to say about Leo sheep, which again, we were talking about Leo sheep. The 10th Circuit said that only applies to when you're building a road across private land. Well, the Ninth Circuit hasn't said that. So what is the Ninth Circuit going to say about Leo sheep? And this is where I'm going to get into my predictions about the Ninth Circuit.
Uh-huh.
The Ninth,
because you clerked in the Ninth
I
Circuit,
clerked-
so you got a little bit of basis for...
Yeah, exactly. The Ninth Circuit is just completely different than the 10th Circuit. Like we said earlier, the Ninth Circuit is the largest circuit in the United States. Yeah. We have what's called 29 active judges, which are judges that have been appointed by the president, confirmed by the Senate, and are actively sitting on the court. That is something like double the next circuit, right? So the big difference there is you're randomly getting 3 judges from 29 judges that span from judges in Montana to Honolulu, Portland to Pasadena,
to Anchorage to...
Exactly. Fair used to be Fairbanks, right? There was a judge in Fairbanks for the longest time, Judge Kleinfeld, who was a great man. So that's the major difference. But another major difference that people don't understand is the Ninth Circuit, because it's so big and its caseload is so large, it has what's called senior judges. So that's judges that have retired or semi-retired from the bench, so another judge could take their place on active status, but still hears cases. Okay. So you have another 20 judges that are like retired, like semi-retired, and then you have what's called visiting judges. So then you have district court judges, so those trial court judges, and other appellate judges that come and visit the Ninth Circuit and sit on panels. So that's all to say, you have absolutely no idea who's going to be on your panel in the Ninth Circuit. Where in the 10th Circuit, I think, and I'm going to get this wrong, but there's like 7 judges, 10 judges. Wow. So you don't know what 3 judges you're going to get, but your odds are you have a lot better idea. Or on the Ninth Circuit, you literally could have, this is 100% truth. You could have a judge from Honolulu, you can have a judge from Anchorage, and then you can have a judge from Georgia. And those people are going to decide whether you're going to jail, whether you're going to own the landowner money, or whether corner crossing is legal in the Ninth Circuit as well.
And the Georgia judge could be there because they're a visiting judge. From outside
exactly.
the circuit.
Yeah.
Okay.
So that's the interesting part. And here's the other interesting part. And I don't want this to be taken as disparaging the former judges I worked for. I know a lot of podcasts, and this is not to point out any podcasts, have a thought of the Ninth Circuit from what it was in the past. And a big reason is because the Ninth Circuit actually expanded greatly under President Clinton's presidential administration. So he appointed something like half the judges on the circuit.
Okay.
So that created what everyone thinks about the Ninth Circuit for so long, because you had, and again, nothing, and this is not to disparage the Clinton judges, but again, it's just a totally different how you look at the law.
Right.
And then President Trump came along, and basically at this point, we have a Ninth Circuit that is almost 50-50 between Democratic appointees and Republican appointees.
Okay.
We have, I believe, if I'm going to get this right, we have 15 judges that are Democratic appointees and 14 judges that are Republican appointees.
Okay.
And I am not somebody to say like Republican appointees are conservative and Democratic appointees are liberal, but it does indicate their legal philosophy. So we have a totally different Ninth Circuit now. It's not your typical city folk, East Coast, West Coast Ninth Circuit. Now you have a really diverse number of judges. But the interesting thing that I always like to say is your still vast majority of your judges are going to be from the bigger cities. Right. So Seattle, San Francisco, Pasadena, LA, San Diego. So what's really interesting to think about there is you're going from the 10th Circuit, a case where you had Judge Timkovich, who's been basically, I'm pretty sure, in Denver his entire life, like truly calls himself, like a son of the West, he's a man of the West. And you have judges from Wyoming and, a lot of relatively rural areas. And then you're going to try to take this case in the Ninth Circuit, where you're most likely going to get judges that are not from rural America.
Yeah.
And again, that isn't to disparage them. This is to say that you're going to have judges that look at this case completely differently. They're not going to look at it as hunting or access. Frankly, they're going to look at it as private land rights.
Property right case.
Exactly.
Yeah.
And the other thing that people need to think about is because you have a lot more of these conservative Republican appointees, private property and property rights are a huge thing of a lot of judges. Because of the takings clause. And I mean, this is not a legal podcast, but takings clause has been a really contentious issue across the United States forever. And a lot of these judges are kind of like salivating to have a, takings case because it doesn't come up that often, because it's not too often that the government comes in anymore and says, we're going to take your land and not pay you for it.
Right.
But what if you come in and say that we're going to allow a 10-foot by 10-foot easement across 3 million, whatever the acreage you said, 3 million acres or 4 million acres. Talk about that takings case.
Yeah.
And it's not saying it's a takings, but like that is how these judges are going to look at it. So if I was a gambling man, which I should be apparently because of how I draw hunting tags, I really probably should be a gambling man.
Yeah, you should.
But if I was a gambling man and I was really trying to predict how the Ninth Circuit would decide this, I would very much lean that they were going to decide it differently than the 10th Circuit.
Okay.
And it's not because the 10th Circuit opinion is clearly wrong. It's because the 9th Circuit is deciding this from a clean slate. The 10th Circuit decided it from Bergen, which was the antelope case, the pronghorn case. The 9th Circuit's going to decide it from a clean slate, looking at Leo sheep and looking at this case that they had in 1913, saying, is the landowner's intent to block off public land? Right. And then number two, you have just a different pool of judges with a different set of learned experiences and life experiences that are going to come at this thinking, a lot of them are going to be homeowners or property owners themselves, right? And come at this and say, how would I feel if I had somebody crossing my land? Yeah. And this is something that you and I have talked about a lot, is that's why if you do decide to corner cross, the way you do it is almost certainly the most important thing, right? How much do you respect the private land? How much do you make sure you are not touching private land? How much do you make sure that you're not causing damage? Which, again, you're not driving across it. You're not taking livestock across it. You're not stepping or driving on muddy roads, that sort of thing. How much are you taking precautions to be what we like to call like a steward and an advocate for public land hunting, right? I mean, when this case as we saw when this case was in the 10th Circuit, these four hunters became, like, I wouldn't say the face, but they became one of the faces and one of the advocacy for public land hunting. And to be completely frank here, they did a hell of a job, right? They did everything right. They were polite.
Yeah.
They were respectful. They did everything in their power to make sure that they did not touch or impede private land access, or private land and property rights, even though they trespassed
Right.
under Wyoming law, according to the 10th Circuit.
Yeah. So when the court said this is trespass,
Yeah.
but it's not reached,
It's-
so I've been as a CPA, I've been an expert witness in a lot of federal court cases.
Yeah.
Calculating damages.
Oh, yeah, absolutely.
Well, I'll provide my idea of damage. The other side, their expert provides their
Yeah.
idea of damage, and the court will say, I agree that it's Randy's opinion or someone else's opinion, or maybe they'll meet in between.
Yeah.
I've never been involved in a federal court case where the judge said, yeah, you did this, but the damages are zero.
So they, I don't, man, I wish I had the cases in front of me. I don't think they actually said the damages were zero. The district court might have said that as an alternative holding.
Okay.
And that's what makes this really interesting. What they said was, and you know what? I'm going to back up. They didn't say the damages were zero, but what they also didn't say is that they also said that if there were damages, we might not preclude them. And this is where we get into this kind of really, really gray area with the 10th Circuit case, where we can literally talk for hours about hypotheticals. And the best part about it is we can just talk hunting hypotheticals for hours, which
Right.
I feel sorry for your entire audience, but in the CLE we did talk about this a lot because there was a bunch of lawyers who understood we're just talking hypotheticals,
Yeah.
right? But the 10th Circuit said we are not saying that if you corner cross and do it wrong, that there won't be damages.
Correct.
But they also didn't say that there weren't damages in this case, which left us in this kind of limbo where we're just assuming that the court held that there weren't any damages.
Yeah.
But the thing about damages we have in the legal field is what's called nominal damages.
Right.
So it's the nominal damages is what it sounds like. You could sue for $1, 1 cent, because your rights were violated, but there's not really an actual monetary damage. So there is a kind of world here where if the hunters did touch the fence like they did in 2020, where they grabbed the fence post and swung their legs around, that the judges said, hey, this is still and again, to be very clear, this is not what the 10th Circuit said, but the 10th Circuit could say in a case like that, like this, your access is still prevented by the private landowner. That trespass is preempted, but we're going to award $1 of damages because you touch private property.
Right.
And then that keeps expanding, right? Like, what if you drove your quad across private property? What if you took your llamas, your horses, or your mules, and they stepped on private property? Well, those damages just keep getting more and more and more. And the court did not decide whether, are we going to give damages or are we not going to give damages?
Right.
Is the damages part preempted by the Unlawful Enclosures Act? And actually, to be very clear, the 10th Circuit said, quote, and I shouldn't say quote because I don't know that for a fact, but summarizing, the 10th Circuit said, we've never held that damages would be preempted, which sort of indicates that they would consider damages in the appropriate case, which keeps getting back to the sense of, man, if you are doing public-facing interactions with private landowners, it's our responsibility as public land hunters to be the best stewards, neighbors, and advocates as we can be to prevent that sort of thing from happening.
Yeah. So one of the other hypotheticals I hear is, well, there's this piece of state land that touches a corner with some BLM land.
Yeah.
Well, state land, no matter which way I'm going, somewhere along the way, I'm not it's not federal to federal. And will the Unlawful Enclosures Act be a defense I can use if someone gets mad at me?
Randy, I think you need to become a legal analysis podcaster because all you keep doing is poking holes in the 10th Circuit case, which we discussed. Yeah. So again, and again, I don't expect anyone in your audience to go read the 10th Circuit Iron Bar case unless they're looking for some nighttime material to go
I
fall
have read
asleep.
it a couple times.
Yeah.
And then I sat there with the class with all you guys.
But if you go into the case, they actually, and you probably can Google this, you can look up the map that you have in front of you right now that
Yep.
shows how they cross. And
Yeah.
one of those crossings is, interestingly enough, state land
Yep.
to federal land.
Right.
But the 10th Circuit and the Wyoming District Court didn't even talk about it. So this is where the legal issues kind of get really messy in the sense that you and I didn't read the briefs. I'm going to admit that. Like, I didn't read the briefs in this case. I read the opinions. So maybe the Iron Bar did not sue over this issue or bring it up. But it is a really weird omission by the courts.
Right.
Because it is such an interesting issue. Here's my best guess. If you're going from state land, if you're going from private land, if you're going from municipal land into federal land, corner crossing, railroad grant, you know where the corner is. I would say the best guess is that is going to be allowed under the Unlawful Enclosures Act in the 10th Circuit. And then the question becomes,
How do I get back?
How do I get back?
Yeah.
You call a helicopter, or you call one of Elon Musk's drones probably that
Yeah.
are going to be taxiing us around, right? We also, I think the best answer to that is because you're allowed in, you're required to be able to get out.
Yeah.
But then the question becomes, okay, I'm on federal land. I want to get to this giant piece of state land that was bought by, Montana or bought by Wyoming or Colorado, because Colorado has a lot of large pieces of state land, which mostly are inaccessible, which, man, that would be something that you and I have talked about a lot at some point. But let's say we're in Colorado where one of those pieces of state land is leased by the state for the purposes of public access. And you're on BLM, but man, that state land where you're at, you have private land on both sides, and all you have is a corner into that state land. Our best guess there is because you're trying to enter state land, it would not fall under the Unlawful Enclosures Act.
Yeah.
You would actually be trespassing, but not only would you be trespassing, you're most likely not going to be covered by the Unlawful Enclosures Act.
Right.
I shouldn't even say most likely. That's our best guess.
Right.
But this is a really interesting thing about being a lawyer compared to what I consider like CPA or being an engineer. All we do is ask questions that nobody knows of until you're a judge. Like nobody knows these answers. We can all kind of hypotheticalize and talk about them and BS around again at Bridger Brewing and around pizza, but nobody knows,
Yeah.
So that's our best guess. But no, that is the really interesting question, especially in a case like this where there is state land, and I believe there's actually city land there as well, right? The city of Hannah or Hannah, I don't know
Hannah.
exactly.
Yeah.
Hannah. Yeah, so those are actually interesting questions that came up in this case. But our best guess is state, private, whatever, to federal, following all the right rules and procedures, probably covered by the Unlawful Enclosures Act.
In the 10th Circuit.
In the 10th Circuit. Coming back after you've done so, also probably safe because you got to escape the BLM that you're not allowed to camp on more than, 10, 15 days, depending where you're at.
Yep.
The reverse, not true, most likely. If you're going from federal land to state, private, whatever. Or let's also say if you're going from your buddy's private to their private that's corner locked, or you're going from state to state, that I would say is more certainly not covered by the Unlawful Enclosures Act, because the Unlawful Enclosures Act talks about federal. Again, this act is from the 1800s, so it doesn't use the word federal public land.
Right.
But that would be our best guess.
Yeah. The reason I ask that is there are 2 states with a ton of state land that is checkerboarded.
Exactly.
New Mexico, which is in the 10th Circuit, and Arizona, which is in the 9th Circuit.
Yeah.
So there is going to be, I would bet any money, a case in there, or not a case, but instances in Arizona where hunters, because we are allowed to access state lands in Arizona if we have a hunting license.
Mm-hmm. Yeah.
But you get to the checkerboard in some of the northeast, some of the east, some of the northwest parts of Arizona, it's mostly state checkerboard.
Oh, it's incredible. I looked at it because I didn't realize how much checkerboard was in Arizona until I saw that map that I had on that for the presentation. It's unbelievable, especially like you said, the north, the west, and the east. I mean, it's just, again, it's mostly state land. Yeah.
Yeah. So my mind's spinning here. All right. There's going to be hunters who are like, yeah, maybe they do it pretty well. And let's say they take the same precautions, the hunters.
Aluminum step ladder, survey marker, everything.
But now we're talking about a different district. We're talking about lands that are not governed by the Unlawful Enclosures Act.
Yep.
I'm not doing that.
That would
I'm just saying, okay, people are going to say, Newberg, you're such a conservative guy.
no, that's not even being conservative. That is one of those things what we call bad facts make bad law. You know, you are putting even though you're doing everything as the polite, respectful, best public land advocate and hunter you can be, you're putting yourself in a position to lose.
Right.
You're taking an out of circuit case that is not precedent in Arizona, and you're not only doing that, but you're expanding that case from way farther than where it really probably could be. And again, we're talking about a federal law here that affects federal land.
Right.
We're not talking about a federal law that says, hey, you have access to any land that you have access to, you can't be prevented from. No, that's generally covered by state law, which, as you know, as being a trustee, that's covered by easements. That's covered by state property law. That's covered by something totally different than federal law.
Right. So I want you to punch holes in my theory here, Dylan. I think the greatest thing that could happen is that the U.S. Supreme Court accepts this case.
Ooh, okay.
Because it's then becomes kind of the law of the land under that fact pattern.
Yep.
It's still the case as decided in the 10th Circuit and at the lower federal court still doesn't address a lot of the important questions.
Yeah.
Because here's some things I worry about. One, some guys in Montana or where Idaho, whatever state it is.
Mm-hmm. We can always blame the Californians too.
There you go. Yeah. Some
non-resident. There's some checkerboard in Northeast California. I'm pretty sure. Yeah.
Well, no, we get some non-resident Californians.
Oh, there we go. That's even better. Yeah.
We got to cast a wide enough net to get everybody here. And we're joking about this because Dylan is from farm country of California.
I am. Like I was telling Randy earlier, if we were playing a game of baseball, I basically struck out the whole inning with all the strikes against me. But yeah, originally from farm country in California. That's how I have all this interest in public land and conservation and all that jazz. But yeah that's why I think I heard it best once on that, people in California, especially hunters, we know how screwed up it is. We don't need to be told. Yeah. We know. we embody it.
So kind of our agreement was if we are going to come up with any examples of bad actors, they're going to be non-residents from California.
Absolutely.
But they could be whatever.
Exactly.
Someone comes to Montana or someone living in Montana gets one of these. So we're already outside the 10th Circuit.
We're in Montana, 9th Circuit.
Yeah. Where we get someone who says, I'm going to cross right there. We got this state to state, or we got one of these examples that
there's several state to state examples in Montana.
Yeah.
Yeah.
Or state to federal or whatever.
Yep.
But I can't find a damn pin here because this isn't a true corner section. Yeah. This is just... they surveyed this and this is a 160 and it touches an 80 over here. I can't find corner pins.
Yep.
Hell with it. I'm doing it anyhow. Close enough.
We had a New York City folk come in and take the survey marker, probably. That's probably what happened.
There you go.
We're going to blame all the we're going to hit all the states before we're done here.
Yeah, we'll blame everyone before we're all done. My point of that is that I worry in the Ninth Circuit, someone's going to do this in a really bad fact pattern.
Yep.
And they're going to think, well, I'm going to prevail because look what happened in Wyoming.
Exactly. Yeah.
And now we end up
with... And you have a 10th Circuit case, again, that we've said isn't exactly the model of clarity. Right. That's the problem. And again, I have a lot of friends that have worked for Judge Timkovich and the other judges on the panel. It's just saying that they had a real tough case, and it's not the model of clarity for all these hypotheticals that hunters, public recreationists, and private landowners think about.
Right. So we end up with, in my worst case scenario, somewhere in the 9th Circuit,
a
bad fact pattern, a landowner is like, I got some really good attorneys. He told me this guy here, he didn't do anything like those 4 hunters from Missouri.
Yeah.
I'm going after him.
Well, not only that, don't forget in Montana, the government already said they're going to come after you too.
Right.
So, like,
Yeah.
let's not forget that in Montana, the government has already said, the state government has already said
Right.
they will prosecute you.
Right.
So let's remember, you're going to be charged criminally and probably get sued civilly in this
Yeah.
case.
So the person doesn't have enough money to defend and go all the way through.
Yeah.
Now all of a sudden we got cases popping up in the 9th Circuit that are counter to the outcome that we saw in the 10th Circuit.
Yeah.
So that's my worry, and that's what leads me to, well, at least if it went to the U.S. Supreme Court, and if they did hear it and just said, you know what, the lower courts were correct.
Yeah.
That gives me some window of relief here.
Yeah. So
Or maybe I'm wrong in that.
there's kind of two ways to look at this. And the first thing I kind of want to tell you, I do want to tell your audience something that we're going to give them a little peek behind the curtain. Whether the Supreme Court will take this case. There's two things that are, one's weighing for this case being taken, and there's one thing weighing against this case getting taken. As your audience probably has seen, there are a whole lot of legal cases going on right now. And I don't care if you're watching news, reading Twitter or X, or just reading your local newspaper, but the courts are busy.
Yeah,
really
really
busy.
busy.
And it's making lawyers like me who just love reading this stuff really, it's kind of interesting. But that's something to say that the Supreme Court has reduced its case, because it's a discretionary caseload.
Mm-hmm.
They've reduced their caseload every single year on average for years now. And so far this year, they're taking less cases than normal. So that's weighing against a case like this being taken.
Okay.
Because to be completely honest, this case matters so much to you, conservation partners like PERC and other conservation organizations, private landowners. But to be completely honest, does it matter in D.C.? No. But the way that they've already worded this case is they're wording it as it's an attack on private property rights, and that's how they're going to word it. So that's one thing weighing against the case. One thing weighing for this case is what we just said. Being taken is this case is not a political hot button issue for the justices of the Supreme Court. This is not gun rights. This is not women's
Abortion,
health. Exactly.
Yeah.
This is corner crossing in a few Western states, and this is something we always talk about in the legal field. There's a Western and East Coast bias.
Really?
Goodness. I mean, on the East Coast, there are if you look at the justices on the Supreme Court, I don't think there's a single one from the West. And there's only been a few.
Gorsuch would be.
Gorsuch is from Denver. Exactly. You have Gorsuch. You had Kennedy from California, and then you had O'Connor from Arizona. And again, they happen, but I'm saying it's very rare. So Gorsuch is one of those people who are going to take interest in this case.
Right.
Gorsuch used to be on the same court, the 10th Circuit,
Right. Yeah.
and I think this is a fine inside baseball kind of thing to say. He's best friends with Judge Timkovich, who wrote this opinion.
Oh, really?
Yeah, I'm not saying they're talking about it. There's some real specific ethics and rules on that.
Right.
But if you read Judge Timkovich's opinion, he specifically cites Justice Gorsuch's opinions that Judge Gorsuch wrote on the 10th Circuit.
Wow.
And that's how. And then this is the inside baseball that you guys that's really hard to know unless you are really following this stuff. Is there are things weighing on both sides. But the main thing to say is the chance of this case being taken is probably less than 50%.
Okay.
And it's most cases. The statistic you always hear is 1% to 2% of cases are taken each year by the Supreme Court. But that includes a bunch of very marital cases that don't have any right to be there. Right. This case is not like that. This is actually a really interesting legal question. Courts and justices have taken a lot of interest in private property rights because there's been a lot of taking cases. And you have, like we were talking earlier, you have 6 justices nominated by Republican presidents. And again, we're not saying what their views are determined by their politics or by the president that nominates them. But that does tell you one thing. These justices care about private property rights.
Right.
So you have things weighing both ways. Now we're going to get to if they took the case.
Yeah.
You have two kind of sides here, right? You have the side of we're going to get a final decision, right? They're going to decide, and we're going to know for all time, that the case is settled in the 9th Circuit, the 8th Circuit, 10th Circuit, wherever you're going to corner cross for all time. And they're also probably going to give us a rule that we can really kind of extrapolate from. A lot better than what we're talking right now.
Not necessarily, though. Will they?
Not necessarily. Again, I don't want to disparage Judge Timkovich or his opinion, but generally the Supreme Court will make a rule that is much more final, at least in some aspects. We'll know some things where the 10th Circuit said there's all these open questions that were not in front of us. And the Supreme Court sometimes does say that, like, these questions are not in front of us. But there are questions I think that the Supreme Court would take that the 10th Circuit didn't touch.
Okay.
Just because they are kind of prevalent in this case, in the sense of, like, can you touch private land or damages, like you said. But now I'm going to get to the bad news lawyer, which, again, you guys can just keep counting the strikes here. By the end of this day, by the end of this podcast, we might actually have like a full baseball game of me striking out. Definitely I'll have a golden sombrero. That's for sure. So if I had to guess, and I know the hunters and the lawyer that had this case is not going to like to hear this, and a lot of your listeners will not like to hear this, I cannot see the Supreme Court ruling the same way the 10th Circuit did.
Really?
And here's the thing. I'm wrong all the time. So, like, I'll be the first to admit, like, I didn't think the 10th Circuit would do this. Judge Timkovich has a reputation of being a pretty judicial philosophy conservative judge, and ruling for public land access and not private property rights was a surprise to me, to be completely honest. Not because that's how I would rule as a judge or anything like that, just based on knowing him as a judge. But like we were talking on the 9th Circuit, you get 3 judges, you have no idea who you're going to get. Right. On the Supreme Court, you get 9 justices, and you know exactly who they are, how they've ruled in the past, and how they have thought about private property rights. And here's what I can tell you. Based on my understanding and how the justices look at private property rights, if they take this case, that means most likely you have 4 justices. Because, okay, let's back up here. To take a case, after all that procedure we were talking about, you need 4 justices to agree to take the case.
Okay.
And you need
4 of the 9.
4 of the 9, and you need a majority, 5 of the 9, to actually make a holding. Mm-hmm. If you have a split case, which probably will not happen in this case, where it would be 4-4, and then a judge that's recused or not able to hear the case, that doesn't even happen. But you need 5 justices to have what's called the judgment. And so you already have 4 justices that looked at this case and said, we want to hear this. Yeah. We want to look at this. And generally speaking, unless you have what's called a circuit split, so you have 2 circuits that have different rules, which we don't have here because all we have is the 10th Circuit case. We don't have a 9th Circuit case. And we have a case, the first case since the 80s. So we don't have like this we don't have this law standard, legal standard, that the Supreme Court's going to want to overturn or change or twist. We have this very discrete case that hasn't really come up or what we call percolated, argued in other courts. So if the Supreme Court takes a case like this, you could be pretty darn sure that there's 4 justices that are very skeptical of the lower court decision. Mm-hmm. And here's the other thing you got to understand. Because they're not taking a whole lot of cases, do you think that 4 justices are going to take a case and then lose on the back end?
Right.
Like these guys, it's not a game, but I mean, they're doing math in their head and they're thinking, hey, if this is going to be one of our 50 cases we hear this year and I'm going to vote to take this case, I probably want to be pretty sure that I'm not writing a dissent. Like I'm not disagreeing with my colleagues. So that's the best way to say that if this case gets taken, I would be pretty concerned for corner crossing across the West. Wow. I mean, that's kind of like the mic drop moment, right? Like, there's not much else to say. Again, because one, you have justices that we know what their opinions are on private property rights, and you have, I would say, 5 or 6 justices that are like really, really strong on private property rights. We have Supreme Court cases that the 10th Circuit has done what we call distinguished, and they've said that these cases, these holdings in cases don't apply in this circumstance. We have 4 justices that said we want to rehear this case, and we also have 4 justices who do not want to lose. Yeah. And by lose, again, this is not a game, but they don't want to be writing in the dissent. Right. They want to make sure that their docket is what they choose their docket. Yeah. So if we're on the side of finality, taking the case is exactly what we want. And, I don't know if this is something we want to get into, but I mean, having finality also opens the door to solutions, which is something
Right.
that PERC and other conservation organizations work on. And we can get into that because there are solutions to corner crossing that don't have to end up in the courthouse with a
Right.
whole lot of money. They can end up with working with your fellow landowners to have public access, to work for conservation, and to work for market-based voluntary solutions and not some sort of regulation.
Right.
But on the other hand, if we want to enjoy corner crossing in very specific circumstances in Wyoming for the foreseeable future, I would be, if you're religious, praying, or I would be knocking on wood if you're superstitious, saying, please do not take this case, Supreme Court.
Yeah. Okay. Well, that's good to hear because I'm not, like I said, I'm not an attorney. I know the practical unfoldings that we're going to see this year.
Yeah.
And I'm less concerned about what we see in the 10th Circuit
Mm-hmm.
and what we're going to see outside the 10th
More worried about the
Circuit.
9th. Yes. Because, like you said, the problem with the 9th is we can have bad facts making bad law. And then, I mean, I would almost say that's kind of the worst case scenario, right? Where we have one circuit where you can't corner cross,
Right.
one circuit where you can corner cross, and really we don't know what the boundaries of that corner crossing is,
Yeah.
right? I would almost say that is the worst case scenario, right? At least with the finality, we can create a market and we can create partnerships to figure out how we're going to create this access or how we're going to create better management of land.
Yeah.
Where if you have two different circuits, well, you're going to have some landowners that are going to say, well, I don't have to let you in anyways,
Right,
go to Wyoming,
Yeah.
Yeah.
Well, one thing that I've concluded from all of this, and in a little background, the audience has heard this. I looked into doing this exact same thing here in Montana
Yeah.
in 2013.
Fun fact for your audience, if you just type in corner crossing like I did for this presentation, you will see evidence of that.
Really?
Oh yeah, do you want a stepladder? I had it in my presentation until I found out you were coming. I'm like, well, I got to remove that. I don't want him to think that I put him on the spot as an example of how to corner cross.
So I went to one of the law firms that has done a lot of cases in Montana.
Yeah.
Actually was the lead counsel in all the things that led to our stream access law in Montana, which many people said was a takings and has been held as, okay, this is how the law is.
Yeah.
And they said, Randy, we understand what you're wanting to do. I was actually going to call the landowner and say, this is what I'm doing opening morning. So if it's a bother to you, have the sheriff there and he can write me a ticket, blah, blah, blah.
Yeah.
And they're like, oh, we can't tell you, anytime you go to court, no one can tell you how it's going to turn out.
You never know.
Our best opinion is, even if you won in criminal court, this would still be civil trespass. And you've spent your whole life as a CPA helping private landowners. You've always advocated respect for private property rights. Do you want to be that guy in a court case and the judge says this is civil trespass?
Yeah.
And so I'm like, no, I do not want to be that person who in any way, shape, or form commits a civil trespass.
Yeah.
And so I didn't do it. And then this case comes along and the outcome that was there, I mean, as a public land hunter, it's like, whew, I like that.
I mean, it opened up so much land. And
Yeah.
as you and I know, a lot of this checkerboard land is prime hunting for elk, deer, and antelope.
Yeah.
I mean, it's just, oh man.
Yeah.
I mean, I don't know about you, but I'm pretty excited to see what happens in the deer and antelope draws this year in Wyoming to see. I don't know about your spreadsheet, but my spreadsheet had corner crossing, yes, no. And I took that into
really?
account for
No,
how the
I
draw
didn't.
odds were going to be.
Really?
Oh, heck yeah.
I didn't go to that detail.
No.
That's interesting. So my reason for bringing all that out there is I know some people are going to say, Randy, I'm not as hypersensitive about these issues of civil trespass that you are, and I get that. Everyone's going to make their own judgment.
And hey, I mean, Ned, I don't want to take anything away from the hunters. There is a federal law that the 10th Circuit held allowed them to do this, right?
Right.
So, yeah, absolutely. It's a personal choice.
Right. And I'm very grateful to those hunters, the way they did this, the respect they showed for private property,
Absolutely.
the way they interacted with the landowner when confronted.
Yep.
I'm very grateful to Wyoming BHA and Buzz and Jeff and all those guys who led the charge for the GoFundMe.
Yep.
We would not be here having this discussion today if not for all the hard work and risk and everything put into this.
It would either still be an open question or likely would have had bad facts, and we would be in a totally different conversation.
Right. So my point of all this is, if you intend to do this,
Yep.
you've got a lot of stuff out there that has told you there are some ways surely not to do this.
Absolutely.
And the ways to do it, if you want UIA, Unlawful Enclosures Act, as your defense, you better have your T's crossed and your
ducks in a row
I's dotted.
Yeah. No, that is exactly right, because there are all these hypotheticals that you, I, and everyone on the forums and internet can discuss. But the thing is, do you really want to be the guy dragged into court to be the one deciding those hypotheticals? Maybe you do.
Right.
It's just, you could do that.
Right.
But I could tell you I won't be that guy.
Yeah. And there's so many hypotheticals. There's not going to be a GoFundMe for every hypothetical.
No, and I guarantee there's not going to be a GoFundMe for the guy that takes their side-by-side to go access public land or stuff like that.
Does something stupid.
Exactly. Cuts a fence, lets cows out to act like there isn't going to be a GoFundMe for everyone. There was a GoFundMe for these people, this group of hunters. They're the first, and they did it. Again, I don't know if you could write a better fact pattern than these hunters did. I really don't know if you could. That is how spot on these guys did it. I mean, I'm shocked that one of them isn't a lawyer, frankly.
Yeah.
I mean, to get like this spot, and I'm not saying lawyers are good, but I mean, to be this spot on and to know exactly the intricacies of how this is going to play out and hitting every one of those pretty much on the dot.
Yeah.
It's one of those things where everything you try corner crossing wise, it's truly at your own risk.
Yeah.
And that's just how it's going to be, because frankly, that's how the legal system works. The legal system works not on like, oh, you can go to a judge and say, hey, judge, I'm going to go do this.
Right.
Tell me if that's okay or not. Yeah. They can't do that.
No.
You're going to have to be hauled into court, and then you're going to get to decide when there's stuff on the line.
Yeah. Well, hunting season's coming up in a few months. Yeah. Everybody is thinking about this stuff. I hear so much chatter about it.
Absolutely.
And I'm still this conservative guy that is grateful for this outcome, grateful for all the people who made it happen.
Yep.
But I'm still super conservative about it.
Yeah, and that's where I'm at too. I mean, it is pretty clear in this case, right? Mm-hmm. But I always go back to what else can we do as, again, public land advocates and public land hunters.
Right.
There are other options here.
Right.
We can work with landowners to get voluntary easements. We can work with landowners to get access. We can do what we used to do before Onyx and Go Hunt and all of the internet, which is go knock on doors, go offer to fix fences for access. There's so many other options, and I'm not saying those options are what we have to do. We have the Unlawful Enclosures Act. That is absolutely certain. My thing that I always say is we have a suite of options.
Yeah.
And in some situations, the best option is probably going to be working with that landowner, because you're going to need that landowner for something else, whether it's conservation, whether it's wildfire prevention, whether it's a land swap at some point. You might need them. Or on other hands, you might have landowners that are like totally fine with corner crossing, and they say, stay at the corners.
Right.
And I think that's really going to be, we can talk about the legal issues all we want, but I think that's actually going to be kind of the most interesting thing that comes out of this corner crossing case is how can we take the technology that we have with mapping software and all these online programs, and how can we make it so that we can work with landowners and public land hunters to get more access, right? Something that we've been discussing is something called virtual posting. Have you ever heard of virtual posting? So virtual posting is it's only in North Dakota, but it's this really interesting posting law where you can post physically. And also to back up a little bit, North Dakota is a state where a lot of eastern states are like this, where if you don't post, you have certain levels of access, right?
Yep.
So you have to legally post. Well, instead of physically posting under the certain rules under the statute, virtual posting allows you to go to the government and on your tax form or to a website and say, hey, my land is posted. I don't want people accessing it. And then it allows online mapping software to go on and put like a giant red box around your land, which is a really unique thing because what it does is it gives landowners certainty that like people are going to know if my sign gets blown over or gets knocked down or isn't there anymore, people still know that they can't access it. But it also gives public land hunters or people trying to get access, if you click on that or go on that and that person is willing to work on access, it'll have their name and phone number. They can choose to do that. But the thing that I keep thinking about is what if we did that but also for corner crossing? Like you gave landowners the opportunity to say, hey, I don't want people accessing my land, but here,
this corner right here,
this corner right here is far away from my house. I want you to cross to that corner. Or, there's a lot of roads out there that were, public, private, that go through these areas. Well, this road technically is private, but it's a good road. I want you to stay on that road and then you can access the public. There are all these kind of voluntary solutions that I think that we should be working, in hand with the legal issues and people like these 400ers who, again, did it totally right.
Yeah.
With frankly, a landowner that probably wasn't going to work on these voluntary solutions. Not that that should be part of the calculus, but, there are certain areas where the landowners aren't going to go for this. And if you do it completely respectfully and you're okay doing it, that is allowed in the 10th Circuit under the Unlawful Enclosures Act.
Yeah.
Yeah.
Well, there's the operation, or the way I operate is hire the best attorney you possibly can and operate in a way that you don't need to use them.
The best attorney is always the attorney that you don't have to call. Yeah. That is for sure.
Nothing against attorneys or anything like that, but so I think we've covered this very well. Dylan, I really appreciated all the feedback and all the other questions that were asked.
Yeah, absolutely.
At that. I got more out just for the practical application of what I do in my life today.
Yeah.
I got more out of that one day with you, and then we did endangered species law.
Yeah,
and
Jonathan Wood.
Then we did the constitutionality and the other parts about federal land ownership and land disposal.
Exactly. Yeah, with David Wilms.
Yeah, those three topics land on my desk a couple times a day. I never went to a continuing education class in the tax world where what I learned that day was on my desk 2 or 3 times a day.
Oh, no, that was the coolest part about it, right? I mean, where can you go get unfortunately, I don't think you got credit from that course, but where else can you go get credit and go learn about 3 of the most top level issues in environmental, conservation, wildlife, and hunting?
Yeah.
I don't know where.
No, I don't either. I hope you guys sponsor and partner with someone to do those kind of things again.
Yeah.
Because we are finding that a lot of our issues in the conservation and access space end up being legal issues these days.
Yep, and that's why. I mean, that is exactly why PERC started their Law and Policy Center, right? Is because it's not enough anymore to do all this research and have all this evidence saying this is how we should run things. It requires you being in the courthouse and in the state house, and that's frankly how I ended up in PERC, right? Is I've been into hunting now for over a decade. I come from a non-hunting family, have a real strong agricultural background, and been around wildlife and bird hunting my entire life. But what I saw going through undergrad and then law school is, man, the other side really knows how to use the law for them. And like, how can I do the same thing for the other, for our side, right? Yeah. And man, PERC is doing it amazingly. And we have a lot of great partners, right? Like we have a lawsuit with RMEF. We've partnered with SCI on amicus briefs. And I couldn't agree more, and I'll be the first one to say, like, it would be so great if we didn't have to go to the courtroom to deal with wildlife conservation issues and hunting. But the reality is, if we're not suing them, they're suing us or they're suing the states. Agencies. And then we have to come in and defend. Not because the agencies can't do it, but man, I know the agencies do appreciate when they have hunters, wildlife enthusiasts, and conservationists on their side saying, hey, you're doing everything right. You have the facts and the stats on your side, and you have the law on your side. We're just going to be here supporting it.
Yeah. So all the legal talk, now we'll get down to the serious stuff.
Yeah,
here.
The things that you and I actually spent most of the time talking about.
Yeah, I have found someone who nerds out on stats and data and draws and history and trends as much as I do.
Yeah, that's what you get,
and his name is Dylan Soares.
Yes.
You are really into this, but your results, the return on your, what my wife would say, wasted time, has been far greater than mine in the last few years. You've already knocked off 3 of the once-in-a-lifetime species in New Mexico.
As a non-resident.
In the last 5 years.
No, I knocked out 3 species in 3 years. And then the year before that, I drew a pretty darn good deer tag in the northwest corner. And if you know anything about New Mexico deer, that's kind of the place to be.
Yeah, 1 to 2% off.
Exactly. Based on my quick search, I don't think anyone else, even residents, have ever drawn 3 of the lifetime hunting licenses in New Mexico. I mean, I'm actually kind of scared to keep saying this because I think New Mexico, they don't have ballot initiatives there, thankfully, like Colorado and some of our other western states. But I'm worried they're going to start petitioning their legislature to say, hey, this guy shouldn't be allowed to apply anymore. He needs to apply somewhere else. He's taking our tags.
Well, pretty soon you're going to be out of the once-in-a-lifetime.
Yeah, if I draw my 2 sheep tags. Yeah. If I do that, I will buy a lottery ticket. Yeah. I'll buy a lottery ticket and promise to donate the proceeds to a conservation organization because, that'd be something.
So do you, like, at home or at work, I'll come in and I'm like, I drew this once-in-a-lifetime tag. And I get the eye roll like, that's the 3rd time you've told us that in 2 years. What do you mean once in a lifetime? Well, that specific tag in that specific unit for that specific species.
Yeah.
It could happen in other states for other species or other units. Yeah. So, this is once in my lifetime. It's funny how people look at you when you say that.
That's the thing is like, the one thing that is fueling my hunting passion is I've been single and I don't have any kids, and that allows me to do what I do, which is as we've discussed, we don't need to get into all of this, but I've traveled a lot and moved a lot, have a few lifetime licenses, and I also apply in a way that really I shouldn't say takes advantage, but I apply based on the statistics. So when I do draw these tags, my family just thinks, because they're not hunters, they're like, oh yeah, Dylan drew this, African antelope on a military base. It was pretty cool. And, he drew this goat in southern New Mexico that's on the Florida mountain range. They don't, to be completely honest, they don't understand what it's like. But I do tell them. And I did at the beginning, I told them, man, I drew this once in a lifetime tag the first year. And I kept saying that. And they're like, well, aren't they now? They're all once in a lifetime. I don't understand how this works. So I've just given up and I just tell them like, here's what I drew. And my parents don't even try to explain what these animals are. They're just like, oh, look what Dylan shot. And everyone's like, I didn't know they had those in the United States. And they're like, oh, is that on a ranch in Texas? I'm like, no, it's not.
Were you you drew Montana mountain goat as a non-resident, correct?
I did.
Yeah.
It was in one of the unlimited sheep units, and man, what wild country. And that was one of those where I drew it, and this is no joke. I drew it, and Montana draws sometimes come out. I think I looked at it like right before I went to bed. I'm like, this can't be real.
Yeah.
And then a couple days go by, and I decide to call Montana Wildlife, and I was like, "Can you confirm that I drew a Montana mountain goat tag? Because this can't be possible." I had 7 points, and I was just like, "There's no way I drew this tag." And they're like, "No, that's your tag. Do you want to buy it?" And I'm like, "Yeah."
Before you change your mind.
Yeah, I remember them calling me. They're like, "Hey, we've seen you haven't bought your tag yet. What's going on?" And I'm like, "Oh, I'm buying it. I have the reminder. I'm just waiting until my paycheck comes in, Like, they're like, "Do you sure you want it?" Yeah. I'm like, "Yeah, I'm pretty sure I want this tag." Oh man. Yeah, no. I mean, we can make your audience, again, we can go down the strikes and make your audience really realize how many tags I've drawn, but it's suffice to say it's I'm either really, really lucky or I've got this draw thing really figured out. One of the two.
You're probably really, really lucky. I went through a hot streak for a while.
Yeah.
I drew Arizona strip, mule deer. I drew the Sheldon pronghorn in Nevada at its
back in the
peak.
day too.
I drew the Gila elk in New Mexico. I drew a string of tags in about a 3 or 4 year period.
Yeah.
Where I'm like, oh, there's nothing to draw on these tags. And then I kind of got the wake up call. Like, Randy, don't think that the anomaly of a streak of good luck is a lifetime projection of how things are going to go.
Yeah, and that's the thing that, Ian, you and I both, our backgrounds are in math, to be completely honest, right?
Yeah.
That's the thing that I've been looking at is like when I look at my statistics, what I always tell myself is each single tag is a different coin flip pretty much, right?
Yeah.
So you never know what's going to happen. Like, again, this year, I think I had a 270% chance to draw tags, which means statistically speaking, I should have drawn 2 to 3 tags.
Yeah.
And so far I've drawn 1. It just so happens that one tag is another once in a lifetime tag in New Mexico. But yeah, so I do think I am going to get a wake up call here shortly. Yeah. But as long as that wake up call means that I'm still drawing like a good tag a year, heck, I hate saying this, but there's some still really good opportunities in the West. Mm-hmm. You just have to really pay with your time, your money, or boot leather. Like there are opportunities here, but you gotta work for them.
Yeah. No, some of the best animals I've ever taken have been on hunts that don't take a lot of points.
Exactly.
And finally, the 5th time I had that tag, I bumped into a really good one.
Yeah.
And I would rather do that than to get it once in my lifetime. Like, when I drew the Arizona strip mule deer tag, it was one of the worst droughts ever.
Yeah.
That tag still sits in my desk drawer unpunched.
I remember you saying that, and that's my new thing is I'm keeping those tags because you need a reminder. You need to humble yourself sometimes when you think that you go on this hunt. You like you said, go to 1-2 point unit, shoot a real nice 6x6. Then you can go back to the drawer and remember it's the experience as well. It's not just killing the animals all the time and harvesting them.
Yeah.
Oh man.
The other benefit I had during that hot streak is herd numbers for everything were so higher than they are today.
Yeah, absolutely.
Wyoming had 650,000 pronghorn. Today they have 350,000.
Yep.
Colorado had, I think, 600,000 mule deer, and now they've got maybe half that.
Yep.
Nevada had 200 and some thousand mule deer, and now they got 70,000. So
yeah,
for you to pull it off under the current herd levels, that's even more remarkable than what streak of hot luck I had going there for a while, but I don't really plan on having one of those streaks again. I think you get one in your life, and count it lucky if you get one hot streak in your life.
And the funny thing for me is that hot streak came right when I started applying. I've been big game for a long time, but I only started applying.
Were you just buying points prior to that?
Yep, I was one of those point buyers, and I always listen to your guys' podcasts and a couple other podcasts about those darn point buyers, and I'm like, I don't know. I don't want to be a point buyer, but like again, I'm going to undergrad for engineering on the coast of California, and then I ended up going to law school where, like we were discussing earlier, there's not a whole lot of public lands where I was going to law school at, and I was one of those dreaded point buyers. But at the same time, here's the weirdest part, Randy. I've drawn one tag based on points.
Yeah.
In my entire time.
New Mexico doesn't have a point system.
New Mexico doesn't
for you to hit New Mexico as a non-resident where we only get 6%.
Exactly.
And it's a pure random draw, and you get 3 once-in-a-lifetime tags.
That's the unbelievable part. Yeah, I mean, I've burnt one. I've had one tag where I burnt points. I had another tag that ended up burning my points, but it was a random tag. And all the other tags, totally random.
Yeah.
Which it's truly unbelievable is what it is.
If you keep on that roll, I am going to request an investigation.
Oh, no. And it's always an open invitation, like if anybody wants to join this hot streak, I'm always looking for hunting partners or always looking for somebody to help pack out my, elk or deer. So, if you want to be part of this hot streak, now's the chance to get on the bottom level,
There you go.
But no, at this point, I've started to think like every time I get a tag, I call the Fish and Game department. I'm like, are you sure? Like, this really cannot be real. And they're like, yeah, you want to buy your tag? I'm like, wow. Yeah, I guess I do.
Well, there's got to be one person who's got a heater. That's what they call it in hockey, man. When you score a goal 5 games in a row, oh, he's on a heater. I guess there's always got to be someone who has that streak. But in 10 years, when we get on another podcast, I'm going to be like, Dylan, you look like you're kind of long in the face here. Haven't drawn a tag lately? I haven't drawn a tag since 2025.
Exactly. Oh, no. Every year I predict it's going to happen. And like this year is the closest that it's happened. I'm not starving for tags. I got some, as everyone should have. We got some irons in the fire still with Arizona and Wyoming still waiting here. But that's why hunting nowadays, I hate to say this, but it's a portfolio, and you got to know, you got to have your full portfolio if you want to have at bats. And like what I tell everyone is, drawing a great tag is great because I've drawn a lot of great tags. But I could say one thing is like I drew these great tags when I had no experience. Yeah. So the amount of at bats I got with those tags taught me so much about hunting. But alternatively, if you're a point buyer or waiting for these tags. You need to get those at-bats somewhere else. And, going on these low point, over-the-counter hunts or whatever hunt you can, again, afford or go on, that's how you get your at-bat. So when you actually do finally draw that tag or get lucky and get on your hot streak, get on your heater, you have that experience,
No, I preach that a lot is, go on as many elk hunts as you want. Don't go 20 years buying points, and then your first elk hunt is a premium elk tag, and you don't have, as you call them, at bats. You don't have these failures, these learning experiences, this
the
other
stalks,
stuff.
The shots.
You might luck out and get one on that one after 20 years, but if you don't have that depth of experience to draw from, you're counting more on luck than you are skill.
And on the conservation side, I'm going to say something else. And the culinary side, spikes and cows taste just as good as bulls. Oh, yeah. And you want to talk about getting at bats, or you're holding in, you're waiting for your archery elk tag in Wyoming or Montana or Colorado. Yeah. Finding cows and spikes during September, you're going to help you find bulls when you have that bull tag, and that's just as good. And, not everywhere has a surplus of elk, but a heck of a lot of the West does. Right. So you're not only helping out conservation by taking those cow and spikes, you're getting your at-bats, you're getting your hunting knowledge, and you're also filling the freezer with some of the best darn meat that you have, that you could find anywhere. That is the other benefit with all the great tags I've had. I haven't had to buy meat in 5 years. I'm pretty pretty big cook since my time, being on places where I can't hunt. I had to get into cooking, and man, 5 years of nothing but wild game. You not only do you learn how to cook wild game really well, but you really learn to appreciate like that kind of quality meat that you are able to get in this country and in where we live. It's truly, truly incredible.
It is. I think about that. How many times I know whatever, we were in mid-June here.
Yeah.
The number of meals I've had of wild game this year is probably more than most people have in a lifetime.
Oh, yeah. No, I mean, when people ask me, what you're making, I'm like, I'm making hamburgers or I'm making lasagna. But what I don't tell them, it's like venison this, venison that, elk this. Again, ibex, oryx, mountain goat. The list goes on and on. That's the other thing. We had a party when I was back in my hometown to make some sausage and make some ground meat. Mm-hmm. And I cooked for my friends mountain goat, ibex, and oryx.
Wow.
And I said, you guys savor this because this is not to be too extreme, but I could pretty much guarantee you're never going to have any of this ever again. Enjoy this pretty special moment because I can tell you I sure am.
Yeah. Well, Dylan, you've provided a lot here. Thanks so much. Appreciate PERC lending you to come and have this discussion.
Oh, absolutely. Thank you.
And I know our audience will get a lot out of it. It'll be interesting. Maybe we'll circle around again when this has worked its way through next phases, if there is a next phase.
Yeah, I mean, there's this case, and like we've kind of alluded to throughout this podcast and in other conversations, there is no shortage of legal issues or policy issues affecting hunting, public recreation, and public access right now, right? I truly appreciate being on this podcast and you giving us the opportunity to kind of talk through these things because the one thing I hope your listeners take away from this podcast is I really just think that there's like you said, there's all this information online, and I hope this podcast kind of gives people a little bit more of an understanding of like what is really happening.
Yeah.
And kind of, again, what I always go back to is it's our responsibility to be the best advocates that we possibly can be because we're on attack on so many different sides that if we truly want to hold ourselves up as these wildlife stewards and conservationists, like you and I both, I at least I try to strive to be, and I know you, you're the model, and also the organizations that we work with and partner with. That's our goal, right? And to be that person and be that group, you have to be real mindful about your actions. And
and the more information people have, the more mindful they can be. And I think we fulfilled our purpose of providing more information. But you know what's going to happen? You're going to get a ton of emails forwarded to you from me because I'm going to get a ton of emails from people. Well, you guys didn't talk about this. Well, how's it going? So I don't know if I'll sick them on you or not. But
yeah, we're going to have to figure out how to do that. I mean, I'm always happy to answer emails in a friendly capacity. But, man, these are the sort of issues where it's like, as you saw at the CLE and you've seen today, we can talk about these things forever.
Yeah.
And the problem is they're all just opinions too.
Exactly.
So, I mean, there's people that are going to disagree with us and agree with us. And all we can do is like you said, do our best to provide as much information about these topics as we possibly can.
Yeah.
Absolutely.
Well, thanks, Dylan. I appreciate it. And folks, thanks for being here. Thanks for listening. I know this was a long one, but I'm sure you got your money's worth.